main modification is needed on that and other matters raised in the reps, and there are quite a few MMs and AMs on this one. Can I just ask for you to run through those for everybody's benefit?
Yes, of course. So the main modifications being proposed, there are a couple of smaller modifications being proposed to Part A of the policy, which includes the of at least 10% with regards to biodiversity net gain. But the main modifications to the policy come under criterion E, which is setting out which sets out how impacts will be looked at with regards to the triple SI, and then the second part of that criterion looking at the loss or deterioration of irreplaceable habitats. So that's just clarified in that wording that's being proposed. There are a couple of other minor wording changes being proposed to other criterions, but another main modification is the introduction of criterion M, which relates specifically to nutrient neutrality.
Yeah, so the latest statement of common ground with Natural England, that's the exam 90 one, that refers to including a reference to local nature recovery strategies in this policy as well. Is that captured anywhere else other than in the statement of common ground, or is that are we to take it from there?
So there is already a reference to local nature recovery strategies within policy wording and within the modification schedule as before you, but obviously the statement of common ground is more up to date.
Thank you, that's helpful to clarify. Okay, I'm going to open this one up. This is question 314, I should have said at the beginning. So I'll open this one up now for discussion. Yeah, the HBF.
Yeah, we welcome the Council's recognition that the plan needs to deal with biodiversity net gain, but I think they've muddled it up. I think the fundamental thing with biodiversity net gain is it's extra and additional to all the existing biodiversity policies that were already in the plan. And we are finding this policy particularly confusing, and the proposed wording makes it worse rather than better, because you have to protect species anyway. Nothing in the European legislation has changed by BNG. BNG is extra and additional, so we would suggest it needs to be two different policies. And then the second policy on biodiversity net gain talks about the local nature recovery strategies and how in future they will shape the review of the next local plan and identify opportunities for local nature recovery in the next plan. But in this plan, it's a material consideration in informing development management decisions where you might focus the off-site credits. And the BNG policy should be very clear that you go down the biodiversity net gain hierarchy of on-site, where possible, off-site, if not possible, statutory credits, and that is entirely different and very easily confused with the mitigation offset hierarchy of the species. So because it's so complicated, this is my kind of full-time job, and even I find it difficult to understand. So our suggestion to the Council, based on our experience, is that you need two different policies, one that talks about biodiversity as happened before BNG came in, and one that talks about biodiversity net gain, which is extra and additional to the current protections for BNG, to avoid or to minimise the chance of confusion, even though we recognise there will still be confusion because there's two biodiversity hierarchies and there's two types of biodiversity. And I think the conversation earlier about the open spaces policy further undermines the confusion, because biodiversity on a corridor is different from a biodiversity net gain site. For starters, that would be my comments, but I'm happy to provide more advice if that would be helpful. But that's essentially the way that we think it should be reviewed.
Yeah, thank you.
So the Council don't see the BNG requirement as being over and above other requirements. They can be captured as part of the kind of wider mitigation strategy, or hierarchy, sorry. So we don't feel it is an additional layer of provision that would need to be required. They could be provided together in terms of demonstrating that biodiversity net gain is met.
you want to come back on that?
I think the council's kind of missing the point. One is about species and one is about habitat and land use. And our members are finding it confusing. I don't know anybody that's working with BNG, including the specialists at DEFRA and MHCLG and Natural England, that fully understand how it all works in practice. So although the metric for the biodiversity net gain requirement is new, and the requirement to use that to show 10% is new, and that is separate and entirely different from anything you have to do to protect species already there, and it's also entirely separate from what you have to do in terms of hedgehog highways and things, because none of that counts. So there's lots of different bits of stuff called biodiversity that's all getting muddled together, and I think this policy is particularly confusing and unimplementable and unsound.
Thank you, Mark. So I think it's entirely appropriate that we have a policy on biodiversity and geodiversity. I mean, this policy sets out a whole range of criteria. BNG, almost the implication of the HBF's comments is sort of overrides or sits above everything else in the plan, which it can't do. And having a policy seeking to protect biodiversity and the criteria which we've got in here, it talks about special areas of protection, special areas of conservation, triple SIs. It's entirely appropriate to set that policy framework out. BNG would obviously benefit in many ways as to how it is applied on a site-specific level from this policy, which would be seeking to protect a number of areas as to how they would sort of apply to a site-specific proposal. But BNG can't sort of override these posts. You have to read the plan as a whole. And in this case, having a clear focus on how we would protect biodiversity and geodiversity, is appropriate, and then that needs to be reflected in the BNG assessments itself. So I certainly don't see it as confusing. If I can't really see in there myself. I'm trying to think whether there's any way we could put clarity in terms of BNG as a requirement, but I can't see myself within there, and I think the fundamental purpose of this policy is completely sound.
Yes.
I wonder if I've not been clear. I think it should be just split out into two policies, so the BNG bit is separate. So all the other stuff is in a policy called biodiversity, and a different policy is called biodiversity net gain, which deals with the metric and deals with the links to the local nature recovery strategy and deals with the hierarchy that you go through for providing on-site, off-site statutory credits, which is different from species, where if you go down the species hierarchy and you hit harm, then you don't do it. Whereas in biodiversity net gain, if you hit can't do 10%, then you buy some credits. It's a completely different process and confusing the two processes. So my argument's more of a process implementation, how it works from a DM, putting your application together, making it clear to members, making it clear to the public point, rather than any kind of policy principle. We support BNG as a win-win for development and nature. We recognise the role that the house building industry has to play in delivering both of those. But this policy, in the way it's worded, confuses the statutory protections of species and the statutory requirement to do better for nature through biodiversity net gain. And we think two separate policies that probably say the same things just in two different places would greatly aid plan users and decision makers in taking this forward.
Madam, can I just ask you a question, please? Obviously, on that side of the room, there's a suggestion that the policy is confusing, and on this side of the room, we're saying no, it isn't. Do you want to give us any feedback as to whether you think it is confusing and whether or not we should be looking to make some changes to the policy? Because obviously, we do want our policy to be clear for the users. Because at the moment we're just one side is saying it's clear and the other side is saying no, it isn't.
Yeah, which we sort of knew would be coming into. But I mean, this really is one I think that we'd want to take away and talk about between us. It's not one where we've understood what the clear solution is that we'd be able to share with you if we're being honest. It was one that we've got written submissions on both sides, and we need to consider it. So Yeah, sorry, not as helpfully like, but it's,
No,
that's-
don't worry.
that's where
I
we
just
are.
didn't want us to be sitting there and you sitting there thinking, well, we don't think it's clear either, and without us having an opportunity to come back and say, well, how can we make it better? But if you want to take the point away, that's absolutely fine. Thank you.
That's what I'd do.
If-
yeah.
No, that's absolutely fine. Thank you so much.
What's happened in other examinations is I've worked with the council on proposed wording for main modifications, and they've been presented before the close of the examination. I'm happy to do that. BNG is the area of policy I lead on for the HBF, and I sit on the national board. So if the council would like to have conversations, I'm more than happy to help in what I think it should say, and then obviously they're entirely entitled to come to their view as to whether they agree with me or not, but I'm more than happy to help if that would be useful.
Thank you, that's helpful, and we'll aim to give that some sort of direction then when we come back to you. It's one of those from on the list, really. So I'm going to move it along to question 315 then. What is the justification for the new addition of the local geological sites and sites of special scientific interest listed in examination document CD23 and the maps? So I think...
I had my board up.
Sorry, did I miss you?
Previous
Sorry, it's difficult. Yeah, go ahead. We'll come back to 315.
Thank you. So in relation to biodiversity net gain, the recommendation of the two national landscapes is that the policy should specify biodiversity net gain of at least 20% within the, for proposals within the either national landscape. That would be consistent with the biodiversity policy in the Cotswolds National Landscape Management Plan and with the equivalent policy in the Malvern Hills National Landscape Management Plan. And if I can briefly run through some of the justification for that. The justification is set out in what is now Appendix 9 of the Cotswolds National Landscape Management Plan. Some of the key points in there are that biodiversity is one of the factors that contributes to the natural beauty of the national landscapes, and therefore the biodiversity is a component of the purpose of designation, which is to conserve and enhance natural beauty. And it's also a consideration in relation to the statutory duty on relevant authorities to seek to further the purpose of conserving and enhancing natural beauty. So in effect, we see there's a duty to conserve and enhance the biodiversity of the national landscapes. Now, you might think 10% biodiversity net gain would do that, but as outlined in our appendix in the management plan, DEFRA's own research has identified that because of the uncertainty around whether the aspirations of B&G will actually be delivered, 10% B&G is actually the minimum that's required to ensure no net loss. So in order to actually deliver a genuine gain in biodiversity, you arguably need a figure that's higher than 10%. And as I say, we recommend 20%. Secondly, the Environment Act identifies that targets can be set in relation to biodiversity, and the subsequent environment target regulations for biodiversity in 2023 identified a target to deliver 500,000 hectares of wildlife-rich habitats across England. Now, the Protected Landscapes Targets and Outcomes Framework identifies that protected landscapes, which is national parks and national landscapes, have to identify half of that total. So they're tasked with restoring and operating 250,000 hectares of wildlife-rich habitat. So they have to deliver half the national target in 25% of the land area, because national parks and national landscapes cover 25% of England. So they have proportionally, they have a higher target in terms of habitat creation. And I think to time with that, it's only right that there should be a higher biodiversity net gain requirement. Protected landscapes, including national landscapes, are also identified in government publications as a key component of the government's nature recovery aspirations, including their aspirations for 30% of land to be managed in a wildlife-friendly way. So those are the key points I wanted to bring forward. Thank you.
Thank you, Bob. So the amendments we've put forward to SWDPR 27, the modification proposed in Part A states at least 10%. So that isn't inconsistent with what's being put forward by the National Landscape. The management plan, of course, itself would be a material consideration in terms of any planning application that came forward, and the combination of the two we feel would be effective in terms of dealing with this issue.
Can't see anything back there. Would you like to come back on that?
I take on board that point, but I think from a developer's perspective, in most cases, they'll be going for the lowest percentage that they can. So I think for the local plan to specify the 20% within national landscapes, that'll make it much clearer what the expectations are in those areas.
Okay, thank you. Did you want anything more to add, or is it's perhaps another one where we've heard
I think it's
both?
probably one for you to take away. I mean, the only middle ground we can think of is maybe putting in a reference to having regard to the management plan for national landscapes. That would at least give it, direct sort of recognition, although... Yeah, I think that... Yeah, there's already a requirement for that in SWDPR 28. So I'm not sure how much additional that would add, but you could put something in this policy just so there's a clearer cross-reference to the two. I mean, I think part of the challenge from our side would be, well, where is the 20%, the evidence behind that and how that's been arrived at itself. So I think, we feel the combination of referring to that document, having a minimum requirement there of 10%, is sufficient.
Okay, unless you had anything else, we've got both sides of that, so I'm going to move that along. Sorry, HBF. Sorry, I think that was you I was talking to, yeah.
Yeah, I think just one point to make is one of the considerations we appreciate is viability, but the research by the University of Kent indicated that increasing the BNG requirement from 10% to 20% has very little impact on viability. The key viability impact is in actually hitting that initial 10% and the additional 10% to reach 20% from their research isn't that significant in that regard.
Okay, I'll turn to the HBF and I'll come to the council on both of those.
Yeah, I was just going to say that many sites deliver more than 10% BNG because the metric assesses what's there already and what's proposed, and sometimes you find it's 56% and sometimes you find it's 5%, and then you have to go away and do more work. So I'd like to reassure you that particularly some of our members are delivering more than 10% anyway voluntarily, but if you make it mandatory, then that means on the sites where it's already really difficult to hit 10%, you can't have any development at all. And on the sites where you can deliver it, there's not an oversupply that can then be turned into units for the people to buy. So I think we don't want to have 20% at this point in time because you may actually undermine the development of habitat banks where people are trying to bring them forward. You may actually undermine achieving more because people will only do the bare minimum to hit that 20% if that's required, and it will impact on viability. And the evidence we have is that every site is so different, you can't come up with a per house figure for how much BNG costs, which is what you need for viability appraisal. So some viability is easily deliverable and some BNG is really not. And it kind of depends what's there. And we're finding brownfield open mosaic sites are particularly problematic, but most of our members are finding the challenge is the availability of credits if they need to go off-site, and those off-site being available locally. So using the local nature recovery strategy and the local plan to provide that market, to give certainty for that market, we think you start with 10%, and then you may find that as the market develops, you can do more, and the next plan can maybe require more. But at the moment, we need to get this current system working, and some developments will and can and want to deliver more than that anyway, but making it mandatory to do more than the 10% is problematic for those sites where the 10% is already a challenge.
Okay, thank you. Do the council have anything to come back through on those two? No, okay. So 315 that I started before was about changes to the maps. I think things omitted in error, perhaps. Do you want to just outline what that is?
Yes, of course. So we've provided a list, I believe, in our response. There are some that have been missed off in error, and that is literally just human error, and some that have been identified as new additions by the Herefordshire and Worcestershire Earth Heritage Trust. The sites relating to local geological sites and sites of special scientific interest were either previously omitted from the Regulation 19 policies map in error, or further data updates have been provided to the councils, and the sites required through modification to be added to the policies map, just so that we are consistent with those sites that are identified.
Okay, that's all I have on policy 27. If anybody else? Looks not. Did we need before we move to 28, did we need a pause for swapping people around, or are we okay? Carry on. Okay, so okay, thank you. Thanks. So we're moving on to policy 28. Question 316 is the requirement in B concerning major development consistent with paragraph 177 of the MPPF? Now, I think there's an suggested on this one to insert some wording. Can you just explain that for me?
Yes, of course. So the proposed modification is to add an addition to the end of criterion B, so that we can include the wording of other than in exceptional circumstances, and where it can be demonstrated that development is in the public interest. This just aligns with the MPPF and the wording within that as well.
Is there another main modification in terms of C that
Yes, so the modification to criterion C has already been mentioned by my colleague in terms of having regards to the latest management plans produced by the Cotswold Conservation Board and the National Landscape Partnership. And then there are some further modifications to criterion D, which talks about cumulative impact and landscape visual impact assessments and when they will be required.
Yeah, so in terms of C, should that, we're back to have regard to, and yeah, so I'm not, to be consistent with, is that intended, or should that just be what we've talked around a few times, which is should it really just say have regard to?
Yes.
Okay, so that's another tweak to the MMs for C then, yeah. Are there any boards up? I can't see any. Yes, there are. Sorry, I can't see yours at all. You'll have to hold it up.
Yeah, thank you. Cotswolds National Landscape. In relation to the proposed modification to B, major development, we don't think that the two national landscapes don't think that change is necessary. We appreciate that reflects the text in paragraph 177 of the September 2023 version of the MPPF, but we don't think it's necessary to explicitly state that in the local plan policy. So the MPPF paragraph says that permission should be refused for major development other than in exceptional circumstances. And therefore, from our point of view, it's quite right that the starting point is that there's a presumption against major development in the national landscapes and that such development shouldn't be supported. So we were satisfied with the wording as it already stood. Now, in terms of how you factor in exceptional circumstances in that scenario, paragraph 47 of the MPPF, September 2023, says that planning law requires that applications for planning permission be determined in accordance with the development plan unless material considerations indicate otherwise. So if an applicant can demonstrate to the satisfaction of the local planning authority that exceptional circumstances apply and that the development would be in the public interest, then that wording around unless material considerations indicate otherwise can come into play. So you can address the exceptional circumstances through that route. I think the wording as it stood without the modification was much more clear-cut as to what the expectations are for development. Also, it's worth mentioning that the MPPF also says that you should avoid unnecessary duplication of policies in the MPPF, and I think that additional text is an unnecessary duplication. So we think the policy wording as it already stood without that modification was consistent with the relevant paragraph in the MPPF. Thank you.
Okay, thank you. Did the council have anything on that? I mean, obviously we've heard both sides of that. Again, it's one of those. But if you've got anything that you want to add.
Sorry, you covered the other questions relating to national landscapes as well. Is it okay if I go through those points as well? You addressed C and D as well, I think, just now.
Hold on, I'm on I think I'm on 316 at the moment. I'm on 316, but we are moving to 317. Is that what you mean?
I thought you'd kind of covered that.
Well, only through the MMs, so I was just kind of like trying to tidy up my areas before we moved it on, but it's fine, we can. I'm conscious that I think Tetlow King want to come in on 316, so I'm going to let them do that,
okay,
and then we'll move to 317 if that's okay.
Sure.
Thank you, ma'am. It's just a very minor point. We welcome the modification to Part B. We heard earlier today about how the local plan defines major development, as being 10 or more dwellings, more akin to like the development management procedure order. The MPPF, in respect of paragraph 177, defines it differently in the footnote. I think it's footnote 60, and it's whether, in terms of consistency of the MPPF, whether the policy should include that definition.
Do you have any views on that in terms of footnote 60 and the definition there versus the other one?
Well, the MPPF leaves it to the discretion of the decision maker rather than specifically defining it. So in order to be consistent with the MPPF, I think we probably need to need to make that change to bring it into line with the MPPF.
Yeah, because major development is defined in the glossary, and hopefully perhaps the definition of major development is set out in the MPPF in Annex 2, but of course the MPPF actually defines major development in the footnote as well. Yeah, so I think we can probably do better in the MPPF and provide more clarity.
I think it's been given special treatment, isn't it, in that context? Yep.
Sorry, could I come
Okay.
back on that?
Oh, sorry, on 316.
Yeah, I think it's a fair point that major development in this context is different to the town and country planning definition of 10 or more dwellings and so on. So it might be appropriate to make a direct link with the footnote, but the footnote doesn't specify exceptional circumstances. So even if you make whilst it might be valid to make a reference to the footnote, I still don't think you necessarily need that additional wording around exceptional circumstances.
Okay, thank you. So I'm going to move on to 317, which is about the requirements of D. So there is an to D to ensure the policy is aligned with the framework wording. Can the council just talk us through what the changes proposed there are?
Thank you. Yes, so there is additional wording at D, so that the criterion would read: development proposals in the setting of the national landscape will need to demonstrate that they have been sensitively sited and designed to avoid or minimise adverse impacts, considering cumulative effects. Accordingly, a landscape and visual impact assessment will be required, and regard should be had of any strategies, policies and good practice guidance produced by the Cotswold Conservation Board and Malvern Hills National Landscape, and the previous text is proposed to be deleted.
Thank you. I'll come to you then. Yeah.
So on this issue, in our submission, we provided some suggested amendments to the wording. So in relation to the national landscape policy overall, I think there's a lot of it where there's elements that could be combined by addressing both development within the national landscape and development in the setting. And also in relation to D specifically, we've suggested there should also be explicit reference to addressing cumulative effects. And one of the things that my colleague Catherine has done since we made our submission is she's put together a table which identifies the modifications proposed by the councils and what our suggested wording, policy wording would be and the reasons for that. So it relates directly to the suggested wording that we put in our submission, but it just links it more directly to the proposed modifications. So we'd like to request if we could submit that document for your consideration.
So those are responses that we've seen already in your statements, but organised in a different way. Is that what you're saying?
In effect, yes.
Isn't in the statement. No, just to clarify. Oh yes, partly. What is in our hearing statement largely has been taken on by the councils in their modifications, but while we were going through our statement of common ground, because the councils had already submitted their major modifications, it was suggested that we just raise the amendments that we further proposed on top of those modifications at the hearing today. So whether it's just easier just to send that table that John referred to yourselves.
So it captures what you've told us verbally today, is that?
Yeah, pretty much, yeah. Or hopefully by the end of the discussion. But whether it just helps in terms of clarity of what we're kind of proposing
As
in
long
addition.
as long as it's nothing extra and it's what everybody's heard in the room today, then that would be helpful for us, because obviously it gives us in writing
Yeah,
what
that,
we're trying to
that's
make
what I was
notes on it.
thinking.
And if the
Yeah.
council doesn't have any objections to us receiving that, and obviously you would receive it too.
Yeah, and they at least some officers have already seen it, so.
Okay, thank you. Yeah, that's fine. Okay, did you have any comments on the suggestions made in terms of D?
We probably need to see what's being suggested, because cumulative effects is still referenced in the policy, in that criterion, so and in the modification. So we're not entirely sure, to be honest. But we're happy to have a look at what is put forward and come back to you if that's helpful.
It's probably our fault, but I think we're a little bit confused as to what their proposals are to our suggested main mods. So perhaps if we can just have a look at what they're saying.
It's probably helpful for us all, I think, to see that in writing.
I
to see
think so.
what- yeah,
Yeah.
that's
Thank you.
fine. Tetlow King, is yours? I can't see it. It is or it's not?
It's down.
Thank you. So moving on to question 318. So it's another one where we're referencing to other documents within the policy. So I think there's an MM here to state that regard is had to the good practice guidance rather than to require compliance, again from previous sessions. And oh yeah, this is the one that we talked, sorry, I'm getting there. This is the one that we've just talked about with the, yeah, okay. Sorry, I've got ahead of myself at the beginning bit. Anybody with anything on that? Your board is still up, is that?
Just to say there are adopted local plans that specify a requirement to be consistent with the management plans. They don't necessarily say compliance with, but they do say consistent with. So there are local plans that have gone through the examination process and been found sound on that basis. So from our perspective, we would be keen to see not just have regard to those documents, but to have consistency or be consistent with those documents, with the management plans in particular.
Okay. Yeah, that's noted, thank you. I can't, oh yeah, sorry, I'm struggling to see anything here now. Yeah, that's fine. It's the Welland, yeah, Parish Council, if you'd like to.
Hello, Sue Hayward for Little More than a Welland Parish Council. Thank you, Ma'am, sir. This question was asking about consistency and whether it would be clear and unambiguous. And I think for settlements that fall wholly within or wholly without a protected landscape, with some of the modifications that have been discussed, I think it is fairly unambiguous. But as I mentioned last month at the previous hearing, Welland is rather unique, and only a tiny number of settlements, I think it's only probably ourselves and Broadway, whose settlement boundaries fall substantially, albeit not wholly, but substantially within a national landscape. And unfortunately, this policy and the existing SWDP policy is not clear and not unambiguous for settlements like ours. And it's led to countless appeals. Basically, we're exhausted and we're challenged as a community by the number of applications that end up going to appeal. It's probably costing the South Worcestershire Councils a fortune as well. And it'd be really helpful to have some clarity in the plan for settlements like ours because of the conflicting interpretations of relevant policies. So as a result of the current situation, we've ended up with significant housing on undeveloped land adjacent to that area of Welland that lies outside of the protected landscape, with plan and development management decision making primarily being based on accommodating district-wide need and as if we were a settlement outside of a protected landscape. But, as I've mentioned, we are, for all intents and purposes, a settlement inside the Malvern Hills National Landscape. The majority of our village lies in the National Landscape. Our village centre, facilities, services, school, shop, playground, everything is within it. And we're also subject to and trying to deliver all the obligations required of a settlement within a protected landscape in terms of we're obviously duty bound to seek to further tranquility, dark skies, and the special qualities. As noted in the RJ for this policy, the nature of the landscape is such that even small-scale development has the potential to have a negative effect on the special qualities of a national landscape, especially where such effects accumulate within those arising from other developments. So, whilst there's ambiguity about how to apply the plan's policies in Welland, we're worried we're going to continue to be the focus of speculative development along our settlement boundary outside the protected landscape, which is not based on relevant local need. And that cumulatively produces impacts that are not compatible with the protections and expectations as a village lying in the national landscape. So development on the sites associated with our village, even if outside the national landscape, as I say, really do affect the special qualities of the Malvern Hills National Landscape. And we'd really welcome some clarity, not in the policy, I think just in the RJ really for this policy, for our unique situation, possibly that for Broadway. And I don't know if there's any other, I mean, I'm not qualified like my colleagues over there to sort of say which ones, but specifically for Welland, we can talk about that although the policy is clear for settlements falling wholly within or without a national landscape, for those small number of settlements falling partly but substantially within a national landscape, such as Welland, and for all development associated with those settlements, we would welcome an RJ saying that decision-making should consider them as if they were in the national landscape for the application of this and other policies in the plan. And we also feel this should apply to decision-making for development sites that are within or in close proximity to the boundary of such settlements, but which themselves might lie outside the national landscape, because that approach would enable consistent decision-making that's coherent with the plan's policies as a whole, the national landscape management plans and guidance documents, and the duty to seek to further the purposes of the protected landscapes. So, sorry that was quite long, but what I'm trying to sort of say, as I say, is as a frequent flyer user of this policy for the purposes of our neighbourhood plan and our local planning decision making, we just really welcome a bit of clarity. Which rock and hard place do we fall on, really? And I say we're not talking about development in the open countryside. We're talking about development associated with our settlement and the purposes of identifying local need that we are defined as a settlement in the national landscape by dint of falling substantially within it. Does that... Sorry, thank you. Thank you very much.
Yeah, can I... do you have a response on that?
Do you want to do it?
Okay.
Let's go.
Having a squabble here as to who's going to take the microphone. I think the answer to the question is, of course, that the MPPF treats development proposals differently, dependent upon whether they're within the national landscape or within the setting of the national landscape. Different tests apply. So even though a large portion of a village might be within the national landscape, if a site which is associated with that village nonetheless falls outside the designation of the national landscape, different policy considerations apply. And that's made clear by paragraph 177 in the MPPF, which we are seeking to reflect in policy 28B as amended and 28D as amended, or as proposed to be amended.
From local knowledge then, is it a Welland situation, or is it a wider spread situation? As
I think you've seen pressures which Welland are referring to there across both districts and Worcester, well, maybe slightly less to an extent in Worcester City, but certainly Malvern and Wychavor with the tilted balance applying. You've seen speculative development across both districts, and obviously the best way of addressing that is to get this plan adopted.
did you have anything? Yeah.
If I may briefly just come back on that, I would argue actually we're a very, very different situation to that because, as I say, every other settlement is either wholly within or wholly without. We are significantly within, but with settlement boundary and adjacent to settlement boundary without. And that puts us in a very different situation. And I'm looking for coherence with the South Worcestershire Council's own policies. RJ 3.3 here specifically talks about how to apply local need for decision making in planning applications. And that would be a bone of contention when talking about Welland if there was a site just outside the settlement. And that particular RJ would not, it would be very hard to determine for Welland as to whether we were in or out. And we would like just a clarity, just for the avoidance of doubt, for those settlements that fall partly but substantially within the national landscape. That, and as I say, there's only two of us, to my knowledge, that this is how this RJ should be applied, or this policy should be applied, because it really is quite a unique situation. And you know, all due respect, but I really don't agree with the situation that's been presented to you elsewhere.
Okay, thank you. We take those points and we take those points. So that's another one where, yeah, thank you.
Sorry, could I make a comment on that, if that's okay? So, in our response to the pre-submission consultation, we had similar concerns in relation to the Broadway, one of the Broadway allocations, which was outside the national landscape, but we took the view that Broadway is a national landscape settlement to all intents and purposes. Now, in terms of what policies should apply to allocations or developments outside a national landscape that are adjacent to a national landscape settlement, case law has clarified that what was paragraph 176 does come into play for development in the setting of national landscapes. So, for example, for development outside of our national landscape, great weight should be given to the impact of that development on views from a national landscape. So paragraph 176 is relevant in that context. For paragraph 177, so the issue of major development, that, as I understand it, is more specifically for proposals actually within the national landscapes. But certainly for paragraph 176 is relevant. And also I think with the wording that we've suggested in our submission and which we've reiterated in this document that we've referred to that we'll submit, we're saying that the wording should refer to development proposals within the national landscapes and their settings. So I think if that wording is used in the national landscape policy, then that will help to address the issue of the kind of developments or allocations which are on the edge of national landscape settlements, but where the development itself falls outside the national landscape.
Can I just add as well that it also then ties in with the section 85 duty to further the purposes in terms of the wording in that legislation where it states where development may so as to affect land within the national landscape. So with the example of that was given with Welland, so even though development may be immediately just outside that designated landscape, but because of traffic movements, increased usage of the village centre that is within the national landscape, for all intents and purposes, it is as a whole, kind of could be considered as being sort of part and parcel of the national landscape. So it's sort of that goes back to that thing of the boundary not being this sort of very definitive edge. But yeah, as John has said, sort of the wording proposed with reference to development proposals in the national landscapes and their setting both need to be, for instance, sensitively sited and designed, kind of covers those bases in terms of legislation. Thanks.
Sorry, one more point as well in that issue. There's now a number of guidance documents and advice documents relating to the seek to further duty. The main one, you could argue, of which is DEFRA's guidance on the seek to further duty, and that does explicitly address the issue of development and the setting of national landscapes and makes it clear that the seek to further duty does apply in relation to development and the setting of national landscapes, or protected landscapes, not just to development within the national landscapes.
Okay, can I have the council's views on the setting point then, and whether that is captured or should be captured in the policy?
I think we're suggesting that it is already captured in the policy under paragraph D, which deals with development within the setting of the national landscape. As proposed to be amended, yep.
Thank you. I'm going to...
Sorry.
I don't know who was first, so yeah.
Sorry, ma'am. Just a very, very quick point. Just to sort of say, we obviously are very, very strongly supportive about the setting point, but our main point is about treating us as a settlement within the national landscape for the purposes of decision making on local need and the other parts of the plan. So that's the main thrust of my particular point for the clarity that we need in here, if that's okay, ma'am. Thank you.
Yeah, we've understood that. Thank
Sorry,
you. No, it's fine.
sorry.
It's worth reiterating, but we've got that point.
Thank you so much. Thank you.
Yeah, just to say in terms of setting, we appreciate it's already addressed in paragraph D, but in our suggested amendments, which we made in our submission and which we'll reiterate in the document that we're going to submit, we also think it's relevant in terms of paragraphs A and C as well.
Okay, thanks. Well, yeah, we've got those points.
Thank you.
Okay, so anybody else with anything on question 318 or that policy before we move along? Your board is up, but is that from last time? Yeah, okay. That's fine. So we're going to move on from there on to question 3110, which is about policy 8, the historic environment. I don't know whether it's worth having a little pause for anybody who doesn't want to be sitting through, who would like to take the leave at this point. I can do that. Yeah?
Shall we take a 5-minute break? Yeah, thanks.
I think we've had the 5 minutes. So we're moving on to policy 8, which is the historic environment. Question 310 is whether the policy duplicates national policy and is it necessary. So I've seen the council's statement and that they're saying that you'd wish to retain, and I appreciate that it was in the previous plan. I suppose the issue we have is that the framework has changed in the meantime, and paragraph 16 says that plans should, amongst other things, serve a clear purpose, avoiding unnecessary duplication of policies that apply to a particular area, including policies in the framework where relevant. So I mean, perhaps it's just one where we need to take a view as to whether it's doing anything extra other than what the framework would do, unless you've got anything to add at this point.
Well, only, which is obviously in our response, Ma'am, that the Historic England's advice is to include a strategic policy. So.
Okay, thank you. So we skip then to 29, which is the management of the historic environment. I have to find that. And the question there on question 319 is the criterion E clear and unambiguous? Does it serve a clear purpose? And what is the basis for the requirement to preserve or enhance the character and appearance of a setting of a conservation area? Which I did have a note on. So I suppose the question on this one is whether there's any overlap with 8 that we've just talked about. The same question would arise as to whether what it's doing over and above the framework, and then is it actually saying the right things, that the same things that the frameworks say?
Yes, so this criterion, as worded on conservation areas, is fairly brief, and I think in reviewing the Regulation 19 responses in the lead up to the obviously to the hearings, we felt that the policy could be strengthened and made clearer with regard to conservation areas. So it does reflect the wording, I suppose, fairly closely in the MPPF, but I think we felt that as it stood and based on number of responses to the Regulation 19 consultation, that it would be helpful to have a slightly stronger, I suppose, or clearer policy on with respect to conservation areas.
So is new G, let's find that, in the MMs, does that definitely reflect what the framework says?
Yes, Ma'am, it is quite close to that.
So when you say quite close, do you know where it deviates? I'm not sure the statutory test is to preserve or enhance a setting. It's to preserve or enhance the asset.
Okay, yes. I think we'll take that.
I think that's where. Sorry, I'm refreshing myself. I think that's where I've come to in that, and I'm just wondering if that's why that question has arisen as to whether we afford such protection to the setting in itself, or is it the asset and then the setting comes afterwards?
We'll take your steer on that one. Thank you.
Fine, thank you.
Madam, yes, I think it's the contribution that the setting makes to the significance of the asset that is the correct approach.
So we'll have a look at between us, and if we have a look at G and make sure that that's doing its job. Sorry, I was just checking through, that's fine. So if we move on to policy 30 is landscape character. Question 320. What is meant by a land cover parcel? So I think there's an MM to provide a definition for that, which is a list of the well, you tell me, it's a definition, I think, is it? And there's a few AMs on that one as well. It'd be helpful if you could talk us through.
Yes, so we acknowledge that, that there's some clarity about what land cover parcel is. So we're suggesting some main modifications with respect to the reason justification. I think specifically to the reason justification rather than the policy itself. And I suppose just to follow that up, we could also include a definition of land cover parcels in the glossary as well.
Yeah, so it's in the additionals, isn't it? That's why it's...
That's correct,
yeah.
Yes.
Question 321 is what's the justification for the requirement of the landscape and visual impact assessment for all major development? I think there's been a shift on that one as well, in terms of MMs.
321? Yeah. Yes, so yeah, we're seeking to, I think as the policy is worded at the moment, it's somewhat confusing with regard to LVIAs and LVAs, obviously very technical sort of aspects of the process. So we're suggesting some wording in there to clarify what development would require either an LVIA or an LVA.
Whereabouts is that then? Is that the additional modifications?
So that's a main modification under 30B and also 30C.
Yeah, thank you. So has the reference for major development been taken away in B? Yeah, it's gone, has it?
Yes.
Okay, thank you. Okay, we're jumping around. So we're back on, we're on policy 10, health and wellbeing. So question 311, what is required in a health impact assessment? I think there's reference here to an SPD that includes a screening template and there's a review intended of the SPD. So is that referred to somewhere in the reason justification?
Yes, it is, ma'am. So it's referred to in paragraph 10.7 of the reason justification.
Yeah, thank you. So that signpost is there. So is there a review of that? Is it an existing one that's been reviewed or is it a new one as suggested?
It is an existing SPD and we will be reviewing it post-adoption.
Okay, so the next question, 3.1.12, is about the justifications for the threshold set out in E, which are in, we agree, are in C, not E. So that's the residential use of 10 dwellings or above 10 dwellings or 0.5 hectares, and then the non-residential uses as well. So how were those thresholds arrived at? And is that consistent with, again, with the major development defined in the framework and in other parts of the plan?
Yeah, so that 10 dwelling threshold has been used throughout the plan, as I've explained, for consistency across the whole of the plan. There is some, there are other local plans that have used the same threshold. I think we've referred to those in our response.
Yeah.
And we just feel that to require a health impact assessment on anything smaller would be too onerous.
Okay. Okay, so question 3.1.3, that's about criterion B. And the question here was whether all of those duplicate other policies in the plan or that apply to the area, and whether in doing so that would be effective. So there are, and I note what's said in the statement, but I'm just whether there are any that in particular duplicate what we've got in just terms of other parts of the plan in terms of design, housing mix, living conditions, GI and biodiversity, and whether, I don't know, I mean, is there any movement on that, or is that one that we're going to have to go away and have a look at?
If you just bear with me on a bit of a long answer. The objective of this policy is focused on healthier communities, human health and social well-being. Those Roman numerals 1 to 9 set out very different aspects of development that are all capable of contributing towards that health and well-being objective. We don't feel it's sufficient purely to rely on other policies. If you're signposted to a policy, and just for example, under Roman numeral 1, you might be signposted to SWDP 16, which sets out a range of percentages with regards to housing mix. It doesn't specifically relate back to health and well-being. It doesn't necessarily give you guidance on how that relates to health and well-being. The list sets out what the HIA should focus on and what it should demonstrate as to how any negative or cumulative impacts could be addressed through that. So we would like to propose potentially further modification to this list to really demonstrate how those points that are raised in those Roman numerals relate back to health and well-being, rather than just signposting to other policies.
Okay, that's helpful. Thank you. I suppose in doing that, the other question is whether how a decision maker would know how to deal with all of those points in terms of a development management colleague dealing with applications, and how are they going to demonstrate that they've met all of them?
I think that would be done primarily through the health impact assessment and would be assessed through that.
Okay, I don't know if maybe B means more of an emphasis on the impact assessments then, in that case, then I'm not sure. Can you look at that when you're looking at explaining how they link back? It might sort of be self-explanatory at that point.
Yeah, we'll look at that and take that away.
Okay, so we're moving forward. Sorry, did you have an... Yeah.
Just picking up on the last point, Madam, if we look at paragraph 7 of the policy, it does say that the health impact assessments will be required to demonstrate how the above priorities, i.e. so how the criteria in paragraph B will be delivered as appropriate. So there is a kind of a linkage back.
Where is that, sorry?
Yeah, if you look on paragraph C of policy 10, as
Yeah, no, I see that, yeah.
So I don't know whether that just might need sharpening up a bit, but I think it is clearly intended that these health impact assessments will demonstrate through reference to the criteria set out in paragraph B how the proposals will be delivered. Is that the sort of thing that you had in mind? Yeah, okay, thank you.
Okay, so we're moving onwards to 40, policy 40, which is tourist development. So question 323 is about criterion A and whether that's justified, effective and consistent with the framework. Yeah, so sorry, I'll let you do it. The response, so can you just outline the response in the statement in terms of, it's about exploring the availability of brownfield sites over greenfield, isn't it? And that's what you're trying to get across. But the question is whether that aligns with the framework, really.
It is about that, and in a free world, that would be the ideal of what we would want to achieve. However, we do recognise that that criterion IV is potentially a little too onerous to require proposals to demonstrate. If you were to advise us to remove it, then we would be happy to do so.
Thank you, that's helpful. Okay, on that basis, and I don't have anything else on 40. So if we move to 31, which is amenity. So question 322 is the wording of the policy consistent with the general protection of amenity set out in the framework. This requires a high standard of amenity. I think there's a proposed to criterion A and an additional requirement sought to be added between A and B. Can you just explain what that does, those two things do?
Yes, so the proposed amendment to A just adds in some additional words so that A would read, development proposals must be designed to avoid creating any unacceptable adverse impact on residents. And then we list out noise, light, odour and effluvia. Then the additional criterion B would read, proposals for new development will be required to demonstrate appropriate mitigation measures in accordance with principles set out below, and they are listed below, where the operation of an existing business or community facility could have an unacceptable impact on users of the proposed development in respect of noise, light, odour and effluvia.
Okay, and I think a question raised by other people is whether it should be designed to avoid creating unacceptable adverse impacts, or whether it should be create a high standard of amenity. Have you considered swapping those over and come to the contrary view?
We feel it should be consistent with the MPPF and therefore should be changed.
Okay, so that's not reflected I don't think that's reflected in the amendments to A.
No,
unless
it's not.
I'm missing something.
No, it's not. No. So that would be another proposed change.
Fine. And is that, yeah, okay. So that's one to be taken on board. Yeah, got you. Thank you. Okay, we're back to 41. I don't know who did this agenda. It's ridiculous. Yes. So 41 is visitor accommodation. And this is about the distinction between within and out with development boundaries in the policy, and whether B would be effective on that. So I'm not sure we've expressed this as well as we perhaps could have done, but I think the issue is that might have to bear with me. So A relates to development within the boundaries, but then B seeks to apply the sub-criterion in A to B, when I think really it's part of A, and it would need repeating in B if you wanted to do it. So the requirements of appropriate scale, type and scale in the A, and the requirements of no adverse impact, they need to be repeated again in B. Is that, yeah?
Yes.
We're on the same page, yes.
We are indeed, because we do feel that the appropriateness of type and scale and also avoiding adverse impact on neighbouring amenity is as important outside of the development boundary as it is within. So we could repeat those 2 points in B.
Okay, so 42, static and touring caravans, chalets and camping sites. So question 325 is about 42A, the first sub-criterion, whether that serves a clear purpose, and I think there's an MM to delete that. Yep. There's on question 326, that's whether account's been taken of paragraph 105 of the framework. It's about the sustainable transport options and whether they vary between urban and rural areas, and whether that should be taken into account. So the MM on that one refers to sustainable and active travel where possible, but I'm not sure if it's tackling the point about the variations that could happen between urban and rural, which I think is the point we were getting to.
I think we'd need to just take that one away and look at the wording in a bit more detail now.
Thank you. I'm just trying to find it. Thank you. Yeah, can I leave that one with you then? That's okay?
Just quickly picking up on that, I suppose we could just start Roman 7 having regards to either its rural or urban location.
Exactly that, yeah.
There are.
That's helpful,
that sort of
thank
thing.
you. Yeah. So question 327 is about small sites and limited proposed extensions or improvements too. There's an additional modification to the supporting text to clarify, I think, what small sites are. And does that deal with limited extensions as well, or do the two go hand in hand?
Having looked at the reason justification that supports this policy at paragraph 3.2, we believe that kind of covers off the explanation that's needed with regards to what is meant by a small site, and also what is meant by the limited proposed extensions or improvements too. Therefore, I would propose just to bring that into policy to make that clear.
to 30 pitches, which is what you've explained in your statement, yeah.
I think the statement just tells you where that information's come from
Yeah.
more than anything.
Thank you. Okay, policy 43 is built community facilities. Question 3 to 8, does the reference to neighbourhood plans in A serve a clear purpose, avoiding unnecessary duplication of policies? So the councils are considering that that wording is necessary. I suppose the question we would have is, wouldn't all development proposals be subject to the policies in the local plans, neighbourhood plans? And do we need to mention, if we need to mention it here, do we need to mention it everywhere?
Given that neighbourhood development plans, once adopted, become part of the planning framework, we wouldn't have any major concerns about losing that wording out of the policy.
So question 329 is in respect of development schemes involving part of a site or a building, and whether criterion B would be effective. I think there's an MM proposed on that to reflect partial loss, and yeah, that's fine, thank you. So there's a rep from the NHS Property Services in their statement that mentions, that suggests a further modification to do with when facilities are declared surplus. Have you had a chance to, do you have any response on that specifically?
So we feel that the I
mean, it might be that the policy already covers it, but I couldn't immediately find that, and I just wondered if you'd had a chance to reflect on what they were asking in their statement.
We feel that the NHS facilities would be covered by the phrase community facility, and therefore would be addressed through the policy as proposed to be amended or as worded. And we don't feel that any further clarification would be needed.
I suppose we could put something in the RJ to make it clear that community facilities includes healthcare facilities, if you thought that was necessary.
We'll take that one away, I think. It's, yeah.
Actually, just on that, the glossary refers to community facilities including health and well-being already.
So it's covered.
Yeah.
Just waiting for you to pick up that point, sir.
Of course.
Question 330 is the justifications for the requirements for the financial contributions set out in F, and whether that would be effective. So I think you've set out that in your statement, and where it's come from and where the standards have come from. The costs are in the IDP, and again will be worked out using the forthcoming developer contributions SPD. So I don't have anything else on that. So we're moving on to 45. Green space and outdoor community uses in new development. Question 333, what is the justification for the green space and outdoor community uses requirements in A? So again, you've referred us on to the open space assessment from 2019. I think there's an not related to that MIQ in particular, but there's an suggested on A. Is that for mixed use schemes? And yeah, okay. And was that just omitted previously, or has it come through consultations with others?
Yes, that was identified through a Regulation 19 response, and we've addressed it through that proposed modification.
Okay. So question 334 is the requirements in Table 9, and then whether they've been prepared with regard to Natural England's accessible natural green space standards and whether those are justified. So there's a statement of common ground with Natural England, and I think there's some. Can you just run us through what the changes to Table 9 are?
So essentially the changes to SWDP 45 in relation to the Statement of Common Ground with Natural England relates to footnotes in Table 9 that essentially recognises that the typologies in Table 9 aren't necessarily in complete alignment or have been produced as a result of Natural England's accessible green space standards. So an attempt to provide better alignment with the typologies in the table, there's a footnote to add that when considering typologies amenity green space and natural green space, there's opportunity to combine those typologies to create a larger green space that would be closer alignment with the local natural green space standard minimum size in Natural England's standards of 2 hectares.
Right, and do those address Natural England's objections? Has that been confirmed?
They've agreed to those changes in the Statement of Common Ground. Yeah.
Okay, so question 335 is about criteria B and C and whether they serve a clear purpose or whether they duplicate other policies, particularly policy 07. I think you've considered that in your statement. There are also some proposed MMs to this for B and C. I think it's removal of reference to the playing pitch and outdoor sports facilities strategy because you're covering it elsewhere. Is that right? Okay. Yeah, that's fine. So moving on to 46 is playing fields. What is the justification for the sports facilities requirements in A? So I think some of this has come out of a statement of common ground with Sport England. Is that right? Can you just run me through if there's any areas of disagreement and what the MMs do.
I don't think in regard to question 336 there was any areas of disagreement. The changes with Sport England, I believe, relate to 337.
Right, that's fine. So I've got a note that there's some MMs to deal with some of their detailed comments, the successor strategy and the playing pitch calculator tool. Are those, I suppose the question is what are those and why are they needed?
Sorry, yes, my apologies. There is one modification to 336, and that does, as you just said, relate to the requirement to consider any successor strategy from the evidence base. Yes, that did come from Sport England. Apologies.
Okay, so question 337 is, we're moving on to criterion B there, whether it's consistent with paras 98 and 99 of the framework that relate to open space and recreation. So B refers to the loss of playing pitches and when they will be supported. I don't know, I think this is along the lines of the previous comment on policy 44 and whether that should just refer to those requirements in the framework just for consistency across and to make sure we're not writing different things in different places.
Yeah, we would like to align with the MPPF to avoid confusion.
So I think paragraph B, Roman 1 to 3, I think is in alignment with paragraph 99 of the MPPF.
Whether it's needed to be repeated or whether we just say in accordance with
Yeah,
the...
yeah, absolutely.
It's just that point again.
Yeah. Yep. Yep.
Okay, so moving on to 50, which is equestrian development. Question 338. Do the first two parts of criteria A together serve a clear purpose, avoiding unnecessary duplication? So the first one relates to appropriate size and scale, and the second to appropriate setting, siting and design. Yeah, I'll ask you just to set out what your thoughts are on that.
Yeah. With respect to question 338, we agree that the aspects to do with design for equestrian development are covered by the other policies in the plan. So we're suggesting as a main modification that that's removed.
Subpoint 3
yeah,
would go.
That's correct.
Yeah,
Yeah.
okay. Thank you. And then moving to 339 is what is meant by all published guidance. So there's an MM to explain the guidance, and that's sought to introduce a list of the guidance that might be taken into account, I think.
That's correct, yes, to the reason justification.
Okay, and then question 340, that's again, it's an issue with compliance with something outside of the plan, so that's the welfare guidelines, which aren't part of the plan. So there's a main modification, I think, to delete that, is that right? Yeah.
That's right, yeah, we accept that point, but we think it's probably useful to have that included in the reason justification, just to provide that sort of extra level of care, I guess, for the end users.
Thanks. So that's everything I've got on policy 50. There was an opportunity now for anybody who wanted to raise anything about policies that didn't have an MIQ, but I don't think we're in that position unless Savills tell me differently. No. Okay, thank you. So that concludes matter 16 and week 4 of the hearing. So thanks everybody for your help today. Sorry it's run on, but it seemed better to try and get through things today than start again tomorrow. Okay, I'll let you.
Yeah, just thank you. So that's the end of this set of advertised hearings. We have the sort of session again on Mitten, where we'll revisit that and we'll sort out how we're going to